Good evening once again, and welcome to our continuous revision towards 2022 Ghana School Entrance Examination. Sorry for the late commencement. As you are aware, it depends upon when I got back to settle down. Very sorry. Tonight, we would like to do Ghana legal system, and we'd like to discuss the law of remedies. So the law of remedies, we are first of all talking about equitable remedies, and then we also discuss prerogative rights, as well as the common law remedies for breach of contracts. So I'm going to give a quick revision overview, and then I will allow those who would like to ask questions to do so before we wind up. So without wasting time, let me also remind you that those of you who probably you have my book or something, you can do more about this by reading chapter 3 of the Ghana legal system and legal method by myself and Nicholas Fredio, or if you have any other standard works, including EK Kwanzaa and all that, you can read more about what we are going to discuss. So first of all, when we say remedies, we are referring to the reliefs which the law provides for various types of infringement of our rights, violation of our interests recognized by law. And it is important to remember that the talk of remedies presupposes existence of cause of action. So anytime there's a cause of action, then we have to ask ourselves, what is the appropriate remedy for this cause of action? So somebody may want to find out, when we say cause of action, what do we mean? Well, cause of action simply refers to a factual scenario or a factual situation for which the law will provide remedy. In other words, anytime you can establish a certain state of affairs amounting to violation of your interests recognized in law, your right recognized in law, that is to say that you have a cause of action. If you have a cause of action, then you have established your entitlement to remedy. You establish that the law should provide a relief for that cause of action which you have against other people. And there are various sets of remedies. We have common law remedies, we have equitable remedies, and we have constitutional remedies. So let us start with equitable remedies, or maybe just due to what you are used to, let's quickly start with the common law remedies, and we'll come to equitable remedies, and then we talk about the constitutional remedies. So constitutional remedies will essentially be the prerogative orders and its various adaptations, as it were. So first of all, at common law, anytime you can establish violation of your rights, either emanating from contracts or from tort or some other situations, maybe breach of a fiduciary obligation, one also was here, know that the law will provide damages, and damages, as you know, are monetary compensations. So monetary compensation, that is what the common law will provide as a regular remedy for a breach of your contractual rights, or where you are being a victim of a tortious action. So as far as damages for breach of contract is concerned, the aim of the law is not to punish the contract breaker, as we know very well, but to place the contract breaker, to place the innocent party in the position that he or she will have been in if the contract had been performed as made. Because when you enter into contracts, you all expect that there will be mutual fulfillment of your obligations. So if I do my side and you do your side, we all achieve the reason for which we entered into the contract. Therefore, if it should happen that I have performed my side and you have not performed your side, there's a breach. So the law should give me remedy, should give me compensation, which will place me at where I have been if you had actually honored the contract. So that is the purpose of awarding damage. It's not to punish. And if you look at the authorities, they are quite clear. Robertson and Harman are this against gramophone and so on. The aim of awarding damages is not to punish, but to fulfill expectation, interest, or sometimes what we call the reliance with interest. We are not doing law of contract, we're doing an legal system, so we are not going to say a lot of things about this, except that as far as damages for breach of contract are concerned, oftentimes we talk about liquidated damages and unliquidated damages. So liquidated damages are where the parties to the contract have actually determined how much money should be paid by a contract breaker in the event of a breach. So that is liquidated damages. And if you look at the authorities, especially the Dunlop pneumatic case, Lord Dunedin, as we know from contracts, provides a very useful distinction. In case you wanted to learn more about this, I think there's a lecture I have done on remedies for breach of contract alone, and I think the video is on the YouTube channel. You can sorry for the connectivity disruption. Yeah, so I was making the point that in case you wanted to get more explanation or revision on remedies for breach of contract, we have a lecture on that alone, which has been done previously. And I think the recording is available on the channel, so you can look for that and get more. Yeah, so, and the other point to remember is that in talking about damages for breach of contract, we talk about the measure of damages and the remoteness of damages. So by remoteness of damages, we are just trying to find out when there's a breach of contracts, what type of losses will the innocent party be allowed to recover compensation? Is it all manner of losses or only certain losses? The general principle is that you will be allowed to recover compensation for losses which are not too remote from the breach. And for this purpose, remember the well-known case of a Hadley against Basendel, as affirmed in subsequent cases like Victoria case. And the point made is that you'll be allowed to recover damages, which we call like the general damages, that is damages which arise naturally in the ordinary course of things from the breach of the contracts. And you also be allowed to recover special damages, that is damages which, because of the information which the parties to the contract had shared, it was reasonable, foreseeable that in the event of a breach, those type of losses will actually arise. And for that matter, the law should allow the innocent party to recover compensation for that. So as Lord Justice Asquith indicated in the Victoria Landry against the Newman Industries case, it will depend very much upon what the innocent party told the contract breaker regarding his or her circumstances before he'll be allowed to recover compensation for those extraordinary losses, right? That we call like the special damages. So let us keep that in mind. And finally, of course, as I've told you, this is Ghana legal system, so I'm being very brief in my discussion of the damages for breach of contract. If you want more, go into the dedicated lecture for remedies for breach of contract, and then you can learn more about this. So the last point on damages, which I would like to draw your attention, is also the what we call the mitigation of damages. In other words, when a breach of contract has occurred, the law requires you, so long as it's not too demanding or expensive, for you to do that which is reasonable in the circumstances in order to minimize your losses. If you don't do that, the court may reduce the quantum of compensation which you'll be allowed to recover from what you could have done, for example, to minimize the losses. Especially so if you could have done something to minimize the losses and those things you could have done was not too burdensome or too expensive, as it were. So let's keep that in mind. And again, when it comes to damages for tortious liability, right? Unlike contract, part of the purpose of awarding damages for torts is to punish the tortfeasor. Because yes, to punish the tortfeasor in some respects. The reason being that you fail to live up to the conduct which the law expects of you, especially if you are talking about, let's say, a negligence. The law requires you to exercise the requisite duty of care. And if you don't do that, and the breach of your duty of care, for example, should occasion injury to the victim of your tort, then you as a tortfeasor, you will be made to compensate the person in respect of whom you fail to exercise the requisite care, resulting in injuries or damages to that person. So in a sense, you are also being made to restore the person to the position that he was before your tortious conduct. So unlike contracts, you see, contracts, when we award damages, we are not just trying to restore the innocent party to the position that he was before the contract. No, we are rather trying to put the innocent party in the position that he or she would have been if the contract had not been broken. So let us keep that in mind. And that's what we call like the expectation interest, right? Or awarding damages in order to advance the expectation interest of the contracting parties. It's only limited situation where you'll be awarded damages, not necessarily to help you to achieve what you expected under the contract, but rather expenses that you have incurred in trying to perform your contractual obligation, what we call the reliance interest or reliance damages. And that will be the case where the court is unable to, for example, determine the benefit or whatever you expected to have achieved if the contract had not been broken. But in the case of tort, it's rather to restore you to the position before the tortious conduct. And of course, where there are other consequential losses, the law will also allow you to recover compensation. And that is why the stability principle is a very important thing in talking about remoteness of damages as far as tort is concerned, especially for tort of negligence. That is, the court will allow you to recover damages so long as the type or the particular or the head of that loss was foreseeable. You don't need to be able to have foreseeing all the details. But if the general type, like you remember the case of the Ray wagon mount #1 and all that, Tort will allow you to recover. So that is about damages for tort of negligence. Of course, what about defamation? Defamation to damages are awarded. And here, as I indicated, damages will be punitive. Punitive in the sense that you are also trying to punish, let's say, that the person who has defamed another person for so doing, quite apart from trying to repair the reputational damage which the defamation has caused. And of course, the quantum of the compensation for damages for defamation will very much depend upon how much value you put on your reputation. And it's not just a question of how much value you put on your reputation, as you'll be able to establish according to how you think that your reputation has been lowered in the mind of right-thinking members of society, as it were. But we come and discuss the tort of defamation as a topic on its own. But as I told you, this is just Ghana legal system, and we are discussing the law of remedies, and we just mentioned damages, and we are just trying to show how damages may be available as a remedy for various types of civil wrongs. We've talked about contract, and we've also talked about tort, as it were. And of course, apart from damages, which is a typical common law remedy, you also have equitable remedies. So let us say a few words about equitable remedies. So as the term suggests, these are remedies which emanated from the court of equity, right? And very much linked to the history of the common law and how equity developed out of the common law, as we remember very well that common law became so formalistic, so rigid that people who had various grievances were not all the time successful in being able to either access the common law or being able to obtain a remedy. And the reason being that the common law had very limited remedy, typically payment of money, damages, but it's not all manner of wrong suffered, for which reason monetary compensation will suffice. So that is one thing. And again, the common law too, as we remember, because of its rigidity, if you could not even get appropriate a course of action, that the appropriate rates to fit your case, you will not be able to even access the court and so on. So all these difficulties and these deficiencies of common law culminated in people who were aggrieved approaching the king direct as a fountain of justice for the king to intervene and do justice according to what was in agreement with the good conscience and fairness. And as we know the story very well, over time, this role was given to the chancellor. And the chancellor initially was usually a religious person, a bishop, and so on. And all these things developed into the chancery court. And the body of principles which emanated from the chancery court were seen to be principles which ensured fairness, which ensure things that accord with the good thinking, good conscience, and all that. And that is why we call that equity, as we know very well. So what were the remedies which emanated from equity? Before talking about the remedies from equity, it is important to remember that, of course, you all know the maxims of equity, but one particular maxim or one particular principle which served as a foundation for discussion of remedies, equitable remedies, is what we call equity will suffer no wrong to be without remedy. So let's keep that in mind. equity will suffer no wrong to be without remedy. And that is very important. And what do you mean by that? That is to say that as far as the court of equity was concerned, insofar as you could establish that your right have been violated, right? Someone had infringed your interests, equity will fashion a solution. Equity will provide a panacea, a relief for you appropriate to the particular grievance which you had. And that is why we say that equity will not allow any wrong to go remediless. Unlike the common law had a very limited remedy. And oftentimes you go to court of common law and the remedy that you get is actually not what is needed. But as far as equity is concerned, so long as you can show that you had a certain interest, you had a certain right in law, that has been violated, equity will provide appropriate solution. That is why we say that equity will suffer no wrong to be without remedy. If equity will suffer no wrong to be without remedy, what are some of the remedies that were available in equity? So first, not in any particular order, we can talk about the remedy of rescission, right? Remedy of rescission. Secondly, we can also talk about the injunction. We can talk about specific performance. We can talk about rectification and all that. So let us take this one after the other and say a few words about them. So rescission. When we say rescission, it's an equitable remedy by which the court seeks to set aside a contract or a transaction and restore the parties to the position they were before the contract was concluded or before the transaction was made. So that is the equitable remedy of rescission. So as you can see, it's actually canceling, right? So setting aside is like you cancel the transaction so that as far as the law is concerned, the transaction is no longer in force. The parties are restored to the position that they were before the transaction was made. And it's available, for example, where where we have like the misrepresentation, right? Be the innocent misrepresentation, negligent misrepresentation, or fraudulent misrepresentation. Rescission could be granted as it were. And of course, we've also seen that where a contract was made as a result of the mistaken identity, right? That is where you have a unilateral mistake as your identity. One party is aware that he or she is not the one with whom the other contracting party intends to enter into a contract. He uses some fraudulent stratagem, and as happened in the cases like the Lewis and Ivory, Flips and Bruce, Candy and Lisa, those type of things. He gets this person to enter the contract with him when he's not the one. So in that situation, equity will grant rescission so that the contract is cancelled and the parties are not bound by the obligation as it were. But rescission as a remedy is not always available. So there are certain impediments or certain bars which can affect availability of rescission as a remedy. So one is affirmation, where you have a transaction. Let's say that the transaction was entered into as a result of misrepresentation or mistake. And having become aware of that, you continue to behave as if you are not aware that you entered into that transaction as a result of misrepresentation or as a result of a mistake or as a result of a duress or undue influence, as it were. Now, where you continue to behave normally and at the transaction, despite the fact that you become aware of a mitigating factor or a circumstance which entitles you to the remedy of rescission. Rescission will no longer be available because you'll be considered as having affirmed. So affirmation of the contract or the transaction, when you have become aware of a ground which entitles you to rescission and yet continues to behave in a manner which shows that nothing has actually happened, will prevent you from assessing the remedy of rescission subsequently. And you know the case of Long against Lloyd, for example, the plaintiff was induced to buy a car from the defendant after hearing representation as to its condition and a statement that it will do about 11 miles to the gallon. The plaintiff drove the car to Rochester, and during the journey, the dynamo ceased to function. There was an oil leakage. A crack appeared in one of the wheels, and then the petrol consumption was 5 miles per gallon instead of 11 miles per gallon. So the plaintiff complained to the defendant, and the defendant offered to pay half the price of a new dynamo. And this offer was accepted by the plaintiff. The next day, the car broke down on the journey to Middlesbrough, whereupon the plaintiff asked for his money back. And a subsequent examination by an expert showed that the car was not roadworthy. Eventually, when the matter came before the court held that acceptance of the offer to pay half the cost of the dynamo and the subsequent journey to Middlesbrough amounted to affirmation of the contract. And for that matter, rescission could not be granted. Because as soon as he became aware that the statement that the car could do 11 miles per gallon was untrue and all that, that should have made you actually pursue rescission. But you didn't ask for rescission right away, and you accepted an offer by the person who made that misrepresentation to pay half of the replacement part we are going to buy. And that disentitled the plaintiff to the remedy of rescission. So the takeaway is that where you have become aware of that ground, be it a vitiating factor or whatever, which will have entitled you to rescission, but you continue to behave in a manner which suggests that you are not aware of any ground entitled to rescission, then subsequently you will not be allowed to ask for rescission. Another impediment to availability of rescission is lapse of time. As we know, delay defeats of equity. So as soon as you become aware of a ground which entitles you to rescission, if you don't rescind the contract and you delay unreasonably, your delay will prevent you from rescinding the contract. And that lapse of time does not work on its own, because sometimes the delay would have also brought third parties. So intervention of third parties. You become aware of the ground which entitles you to rescission, you don't apply for it. That transaction which you have been entitled to have it rescinded, let's say that other parties acquire interest in that transaction, then it will become complicated for you to get the remedy of rescission, because it's not about you alone. Other people have come into the picture, and for that matter, if it is rescinded, the interest is also going to be affected. And that is why equity will say that because of intervention of third-party rights, you will not be allowed to have rescission. And again, where restitution in integrum, in other words, if it is not possible to restore the parties to the status quo ante to the position that they were. Where restitution is not possible, rescission will not be allowed, because the purpose of rescission is to cancel the contract so that the parties are taken back to the pre-contractual or the pre-transaction situation. So if the pre-transaction situation is unattainable, then rescission cannot be applied. Another equitable remedy we'd like to discuss is the remedy of injunction. An injunction, as we know, is a very popular equitable remedy. So first of all, what is an injunction? An injunction is an equitable remedy by which a court restrains a person from doing a particular thing. Where a court restrains a person from doing a particular thing, or where a court orders a person to undo a wrong which the person has actually committed. That is an order of what? Injunction. And as we know, it is a remedy which developed from the court of what? Equity. So let us keep that in mind. And there are various types of injunction, as we know. We have a mandatory injunction. So mandatory injunction is, if you like, positive, where the court is actually making an order against a person to do a positive act. Let's suppose that you have maybe dump refuse, right, in front of somebody's house. Mandatory injunction could be directed against you so that it will clear the refuse from there. So you are directed to reverse a wrong which you have committed. So that is a mandatory injunction. And you can look at the case of Sky Petroleum Limited against VIP Petroleum Limited, decided in 1974, 1 or England Report 954. In Sky Petroleum Limited, the parties entered into a 10-year agreement in 1970, under which VIP undertook to supply all Sky Petroleum requirements. There was a dispute in 1973, and VIP refused to continue its supplies to Sky. And because of an oil crisis at the time, Sky found itself unable to secure any other source of supply. So the court granted a temporary injunction against VIP, restraining it from withholding a reasonable level of supplies. Just like, for example, what is going on in the, let's say, Russia and Europe, especially Germany, right? There's a contract between Russia and Germany, other European countries, to supply their gas, needs and all that. But because of war, there's this concern that Russia, as part of its war strategy, could threaten to withhold the supply and all that. So assuming such a matter were to go to court, it will be a good candidate for mandatory injunction, in which case the party who is supposed to supply the gas or the petroleum will be directed not to cease, right? Not to cease the supply and so on. Or when it comes to contract in restraint of trade, contract in restraint of trade, especially where there's employment contracts, you have a clause that upon leaving employment of your employer, let's say that you are not going to either work for a rival business and so on, or maybe a business has been sold to you and there's a clause in it to the effect that you are not going to set up the same business within a certain geographical location, within a certain a reasonable duration and all that. And let's suppose that soon after selling it, you set up a similar business within the forbidden radius the court can order you by injunction so that the mandatory injunction so that you abide by your contractual obligation not to do that which you said you do as it were. Then we also have a prohibitory injunction. But you see, prohibitory injunction, the court is directing a person to refrain from or discontinue a wrongful act. No, and typically, if you want to distinguish that from the mandatory, in the case of the prohibitory, oftentimes the act which you are being restrained from is either you're about to do it or it's ongoing, right? It's an ongoing wrong which you are indulging in or infringement, as it were. Then you are prohibited so that you are ordered to refrain or to desist from doing that. Unlike the mandatory, where typically the wrong has actually occurred and it is not necessarily ongoing, and you are ordered to reverse that which you have done. That is like the mandatory injunction. Yeah. So if you take the case of the Cold War in International against practitioners in marketing, reported in 1971, one weekly law report 361, which I have cited at the page 40 of the Ghana Legal System book I told you. A manufacturer was restrained from breaking a sole distributorship agreement by another, preventing him from disposing of the goods to which the agreement related in any other way. Now, if you read that case, what is happening is that the breach which the court was ordering the other party to refrain from was, if you like, of ongoing. So prohibitory, oftentimes, what is being prohibited may be an ongoing wrong, as it were. Then you are restrained or you are ordered to refrain from doing that, from indulging in that wrong. Whereas mandatory, oftentimes, the wrong is consummated, is actually crystallized, has happened, and you are made to reverse it or to undo it as it were. But the other point to remember is that whether mandatory injunction or prohibitory injunction, it may take the form of interlocutory injunction or perpetual injunction. In other words, mandatory injunction and prohibitory injunction may be either interlocutory injunction or perpetual injunction, or you may even add a temporal or what they call the interim injunction. So let us explain what we mean by this. Let us start from interlocutory injunction. Interlocutory injunction refers to an injunction which is granted during the pendency of a suit. So a case has been taken to court. Now, before the case is finally disposed of, so that the parties know their right in terms of who is victorious and who is not victorious, it may be necessary to preserve the status quo. It may be necessary to freeze the situation so that nobody will take advantage of the other. When the case is finally disposed of, whoever is victorious will go and do that which was stored or which was frozen by the injunction. Now, because the injunction is ordered or is granted during the pendency of a suit, because the case is still ongoing, we call that interlocutory injunction. Now, related to interlocutory injunction, we also call interim injunction, right? Interim injunction is a subset of interlocutory injunction. What do you mean by interim injunction? if you look at our rules of court, for example, it says that where you need an injunction, there's a pending suit, you could apply ex parte, that is, you go to court on your own, make a case to the court that due to exigencies of the situation, it is necessary for the court to order the other party or to make certain orders in the nature of injunction to preserve a certain situation, the status quo. Now, the court can grant that and give you, say that, well, it will remain in force for 10 days. So that injunction, which is going to remain in the period not exceeding 10 days, we call that interim injunction. Interim injunction. But after 10 days, you have to repeat on notice. You have to repeat the application and bring the other party to court so that he or she will come and also react to the request which you are making to the court to grant you that injunction. So when that is granted, it will no longer be interim injunction, that will be interlocutory injunction. Interlocutory in the sense that it's going to remain in force until the case is disposed of. And when the case is finally determined, the interlocutory injunction will automatically come to an end. If the court would like to grant injunction following conclusion of the case, that will be what we call perpetual injunction or permanent injunction. And permanent injunction, as the name suggests, remain in force for eternity, so to speak, unless maybe there's an appeal, a successful appeal against the decision, and the appellate court will reverse the judgment or the decision in which perpetual injunction was given. Or maybe you have a judicial review, and then the decision in which the perpetual injunction was given is, for example, quashed by certiorari or like that. Otherwise, it will remain in force. So let us keep that in mind. So the takeaway is that interlocutory injunction is the injunction given during the pendency of the case. Perpetual injunction, also known as permanent injunction, is given when the case has been concluded or not on merit. And as I said, it will remain in force for so long as the court, like a higher court, has not reversed the decision in which it was granted. Now, we also have what we call Mareva injunction, Mareva injunction. And Mareva injunction is actually granted where there is a risk that something which is being litigated or a subject matter of a contract is in danger or being removed from the area of the cause jurisdiction. So if there's a litigation relating to a transaction or a contract, and there is maybe an item or a property, and there's a fear that the subject matter of the contract, which is under the litigation, is being removed from the jurisdiction of the court, Mareva injunction could be granted. And as you know, Mareva injunction emanated from the case, which is known as the Mareva Compania Naviera against International Bulk Carriers. And it was granted in order to prevent removal of assets from the jurisdiction of the court. And that is why it is so called. So therefore, if you look at Lord Dass's Kerr's dictum in a case known as Z Limited against AZ, this is how he explained Mareva injunction, and I quote, Mareva injunction should be granted when it appears to the court that there is a combination of two circumstances. First, when it appears likely that the plaintiff will recover judgment against the defendant for a certain or approximate sum. Secondly, when there are also reasons to believe that the defendant has assets within the jurisdiction to meet the judgment in whole or in part, but may well take steps designed to ensure that these are no longer available or traceable when judgment is given against him, unquote. In other words, where, for example, there's a case against a company and the company or the party knows that should the case go against it or against him, its assets are going to be attached in execution so that he or she decides to move the assets outside the jurisdiction of the court so that in the event of a judgment against it, those assets cannot be attached in execution of the judgment. Now, the other party, should he become aware of any such move, can quickly move to the court and ask for an injunction known as Mareva Injunction to prevent the other party from actually taking steps to remove the assets beyond the jurisdiction of the court. Of course, it is a bit similar to what we call interim preservation order, injunction in the nature of interim preservation, but they are not necessarily the same, because the injunction in the nature of interim preservation is where you have sued someone and you do not want the person to sell his assets or gift his assets, and you want his assets to be preserved until the case is finally disposed of. The reason being that if the assets are not preserved and he or she disposes of them, should you win the case against him, you will not be able to execute the judgment. In other words, you will not be able to get his assets and have them attached and sold in satisfaction of the judgment. For that reason, during the pendency of the case, you may want the assets to be preserved. And when it is so preserved, it is also a type of injunction. So injunction in the nature of interim word preservation. It has a similar effect as Mareva Injunction, but the difference between Mareva Injunction and what we are talking about is that the Mareva Injunction, oftentimes there's an attempt to take it outside the jurisdiction of the court. Yeah, but the end result are the same: to keep the assets pending determination of the suit. Then there is also a type of injunction known as the Anton Pile injunction. Anton Pile, or some would say Anton Pile, is an injunction which authorizes the inspection and then photographing or taking away of documents or other property into custody other than by the applicant. What do we mean by that? When it comes to, for example, intellectual property type of cases, right, where there's a suspected infringement of someone's intellectual property, copyright or whatever, it may be necessary for the court to give orders so that unknown to the other party against whom the order is going to be exercised, they can just enter wherever there's suspected infringement for them to go and have access to the information. Or if you take the original case in which that type of injunction involved, what we call the Anton Pile KG against Manufacturing Processes Limited, reported in 1976, CH page 55. A German manufacturer of frequency converters for computers feared that his English agent will pass confidential information of a new range of machinery to a competitor. So the German principal obtained an injunction against the English agents, authorizing the principal solicitor to enter the agent's premises, to inspect the relevant documents and to remove them into the solicitor's custody. So that is how the name Anton Play injunction came about. Another equitable remedy we want to touch on briefly is the order of specific performance, or the decree of specific performance. So as the name suggests, it is that remedy by which the court orders a party who has made a contractual undertaking to carry out exactly the obligation or the undertaking that he or she made. So here, and of course, this particular remedy, it evolved against the backdrop that the common law, which awards monetary compensation for all manner of contractual breaches, is sometimes deficient, because it's not all the time that a party to a contract which has been breached by the other will be excited to get money paid to him. He or she may want the contract carried out and not just being paid money. And for example, we know when it, let's say, a land transaction, you want to buy a parcel of land in a particular location, and you have fulfilled the payments. The vendor is not prepared to convey the land to you or put you in possession. That is a breach of contract. But if you go to court, they are not just interested in you getting the money back and maybe some other compensation, because you desperately need that particular land in that particular location for whatever that you need it to do. And as we know, land, location is everything. So therefore, if you are giving money, you may not even get land at that same location. For that reason, you may want the other party to be compelled to actually honor the particular contract that he made, that he will give you that parcel of land. So therefore, what are the conditions for the grant of specific performance? First, it will be granted where damages will not be adequate remedy. So whenever monetary compensation will not be adequate, will not be sufficient, the court will be prepared to grant a specific performance as a remedy for breach of contract. And two, where specific performance will require constant court supervision, it will not be granted. So if it requires the court to constantly supervise, then it will not be granted. But where it does not require constant supervision by the court, it will be granted. Of course, we've made the point that when it comes to land, as well as commodities or properties which are considered rare, they are rare in the sense that if you even have money, you'll not be able to get it to buy, then the court will be more inclined to grant another specific performance, because if you are giving money, you will not be able to get it. And you all know the famous case of Redco Limited against Sapon in relation to the purchase of the flat in the place that we call like the Redco around the Medina area, where the court was prepared to grant specific performance in relation to agreement to construct a flat and make it available by a particular date. Again, where specific performance will result in hardship, the court will not be prepared to grant it. So where the grant of it will cause unreasonable hardship in the sense that having regard to the particular obligation, there's no way that it can reasonably to be carried out. If it cannot reasonably be carried out, then the court will not order that you must necessarily do what you undertook to do under the contract. And above all, the court will have to find out whether it will be just and equitable. In other words, will it be just and fair, having regard to all the circumstances, to grant specific performance. And we know that he who comes to equity must come with what? Clean hands. That is to say that, for example, when it comes to contract, let's suppose that you, the person asking the court to grant specific performance, it can be demonstrated that you prevented the other party from carrying out its contractual obligation. So where you are to be blamed for having prevented the other party from carrying out its contractual obligation, then it will lie foul in your mouth to ask the court to order the other party to fulfill its contractual obligation when you are the same person, you are the very person who prevented him from carrying out his contractual obligation. You cannot actually approbate and reprobate. You cannot eat to a cake and have it. You cannot prevent someone from carrying out his contractual obligation, and later on you turn around when they are not able to carry it out and tell the court that the court should order him to carry out his obligation. So therefore, he who comes to equity must come with what? Clean hands, and the court will refuse to grant the specific performance. Another equitable remedy worth touching on before we leave these equitable remedies is what we call the rectification, the remedy for rectification. So rectification is an equitable remedy which enables the court to rectify, that is to correct a document executed by a party so that it will accord with their true agreement. It will reflect their true intentions. It may so happen that when the parties were having the negotiations, they reached a certain agreement. But when subsequently the agreement was reduced into writing, it did not accurately reflect the prior oral agreement. So the intention of the parties are not properly reflected in the document. Now, subsequently, when one becomes aware that the document that they executed does not accurately reflect their intention, he or she will go to court, and the court could decree that the document should be corrected so as to reflect the true intention of the parties. And on this occasion, the parole evidence rule under section 177 of the Evidence Act will not apply, because here the Court of Equity will be convinced that the documents before it does not completely and accurately reflect the true intention of the parties, and that it needs to be amended so that it will accurately reflect what the parties had previously agreed upon. So in a nutshell, these are the equitable remedies. Because of time, we cannot continue with the other constitutional remedies, and especially the prerogative orders. Maybe in a subsequent class, we do a brief discussion of that. So I will pause and take questions and comments before we end the night. So if you want to ask a question, just let us know, or if you want to add to what we have discussed. Yeah, so if you just make sure that only one person speaks at a time so that it doesn't jam, you can unmute yourself anytime. Okay, so in absence of questions and comments, have a very good night and continue tomorrow.